Afternoon. I'm Georgia Mason. I'm director of the Campbell Centre for the Study of Animal Welfare. Let's acknowledge first the land we're on and recognise that this country resides on the traditional, unceded and treaty lands of First Nations, Inuit and Métis people. For those of us in Guelph, we're of course based on the traditional territories of the Mississaugas of the Credit First Nation, one of the Anishinaabe people. And if you want to learn more about them, I'd strongly recommend their excellent website. The University of Guelph also resides within the Dish with One Spoon territory, which is an agreement to live in peace between the Anishinaabe people and the Haudenosaunee, effectively the Six Nations. And it's on Six Nations land that our closest residential school was run. And I bring this up because it's now called the Woodland Cultural Centre. And on February 19th at 6 o'clock, they're screening online a movie about this school. So if you want to learn more, I'd highly recommend it and Google Woodland Cultural Centre. Okay, back to the event of the day. So this is the third in our animal law mini-series. We've had two talks so far giving an international perspective. They're up on our YouTube site. And this is the first of three talks that will focus on Canada and the problems in this country and an array of possible solutions. So I'm really thrilled to have Camille Labchuk kicking off the first of these three talks. Camille is a lawyer who specializes in animal law. She graduated from the University of Toronto Faculty of Law and Mount Allison University in New Brunswick. She's executive director at the legal NGO Animal Justice, and Animal Justice works to pass strong new animal protection laws. It pushes to hold industries accountable for harming animals, and it fights on behalf of animals in court. So Camille today will speak for about 45 minutes. The talk will be recorded on our YouTube site. There'll be a question session at the end, which won't be recorded, so you can be kind of relaxed there. And it will be via Zoom chat. We'd love to open it up, but we've had some really terrible Zoom bombers, which have traumatized us. So if you have questions, pop them in the chat and I will read them out at the end. Okay, Camille, the floor is yours. Thank you very much.
Thank you so much, Georgia. Thanks for the warm introduction and the welcome. Thank you for hosting this series in the first place. I've really enjoyed the previous presentation so far, and I'm looking forward to the rest. And I'm really honored to be sharing some insight, hopefully, with all of you today. So I'm going to speak about why I would say that Canada's animal protection laws are badly broken. I should have put the word badly in the title because that definitely applies here, and take you through a variety of different issues with them, and then hopefully leave you with some suggestions at the end for how we can improve the situation here in Canada, and including how some of us can play roles in doing that. So just a little bit of background on me before we get going. In addition to what you heard, I grew up on Canada's East Coast in Prince Edward Island, and some of my earliest memories of caring about animals were seeing images of the commercial seal slaughter on television. And I just couldn't understand why people would go out there and club seals for fur. It really broke my heart. And I, felt passionate about animals from an early age. I had cats, we had hamsters, we took care of rabbits and ducks. And later in my life, I didn't necessarily think I would end up working in animal law or animals at all. I worked initially in politics after I finished university for this woman here, which is Elizabeth May. She's the leader of Canada's Green Party. And it was there that I started to become inspired a little bit more to consider going to law school to use legal tools to make social change, which is what I was interested in doing. I'd already become vegetarian and vegan by this point. I knew I wanted to try to do something for animals, but I didn't really expect that that could be a career option. Things came full circle for me somewhat in about 2007 when I was first invited to go out for the first time to the commercial seal slaughter with Humane Society International. And HSI was out there filming the reality of the seal slaughter and using those images to help convince the European Union and other jurisdictions to ban the import of seal products. They successfully did that, and it led to a massive reduction of numbers of seals killed every year, to the extent that the seal hunt is now a shadow of its former self. So for the first time, I realized, being out there around professional animal advocates, that this was a viable career path. And I decided to combine my interest in law that I'd gained from Elizabeth May, a former environmental lawyer, with the interest in animal advocacy. And I went off to law school to see what kind of difference I could make. I didn't think that the path was going to be easy, because when I started law school in 2009, there were no animal law organizations. Animal justice was just being set up, but it was really just a website and a couple volunteers at that point. But I'm happy that today in 2025, we are a much larger organization. We are fighting cases in court. We are passing federal laws and laws at the provincial level to protect animals. And we're, I think, moving the needle for them. So, outline of my talk. I'm going to take you through the federal and provincial protections that do exist for animals, or the lack thereof, which is more often the case. We're going to talk a lot about private standards, and you'll see why when we get to them. I'm going to deal with the whole question of enforcement of animal laws and why that system is also problematic. And then we're going to move into solutions. So, the primary reason I say that our laws in Canada are broken is that we don't have any. For the most part, we simply leave industries unregulated. Unlike most other G7 countries, Canada has no federal animal welfare legislation that unifies the country or that sets regulatory standards for animals used in industries like farming, like the pet trade, the zoo industry, or animals used in science. So this is just a massive, massive gap. Now, it's not to say that there aren't any laws. At the federal level, we do have some laws. We have the Federal Criminal Code of Canada. Criminal Code is not a regulatory statute. It doesn't set standards that must be followed, but it does say, here's the things you can't do as citizens of Canada for moral reasons. And that includes prohibitions against being cruel to animals. So we do have those. We also do have regulation and true regulation of animal transport and slaughter. Those are the only areas truly that the federal government oversees when it comes to animal farming or really almost any other animal issue. And I'm going to take you through these laws shortly and show you that even though they do exist, the standards are weak and the enforcement is ineffective and patchy at best. But first, let's just turn quickly to provincial laws because there are some of those as well. So provincial laws, unlike the criminal code, which I mentioned previously is more about prohibiting specific acts of cruelty, provincial laws are more oriented towards setting standards that must be followed to ensure animals don't experience distress, for instance, don't experience a deprivation of food and water, of veterinary care. So they set these standards that generally apply to the keeping and ownership of animals in provinces. Now, the problem is that oftentimes, while they do regulate some activities, they leave a lot of other activities out. So there aren't comprehensive laws on breeding animals in most jurisdictions. Zoos are a bit of an exception. Most provinces do have some rules governing zoos. Ontario being the massive exception to that. Probably many of you here know that Ontario is the worst province for zoo regulation because there is none. But the biggest problem when it comes to provincial statutes, I would say is that there are giant exemptions for industry. So even though there's general standards that should apply to most animals, industries often get a jail free card. So look at this last point here. Often there's exemptions for quote unquote reasonable and generally accepted practices of agricultural animal care, management, or husbandry. So what does that mean? It kind of sounds like if an industry, and in this case, the agriculture or farming industry, decides that a practice, even though it causes distress to an animal, is standard and accepted in their industry, that essentially is outside the purview of the law. So we're going to come back to this in quite a bit more detail later, but just to leave that hanging over your heads as part of the reason why these laws don't really operate as they look to operate on the books. Let's go back to the federal regime and examine that. So I mentioned we have the Federal Criminal Code. It says that a person can't cause unnecessary pain or suffering or injury to an animal. You also can't cause willful neglect. Animal offenses are housed in the area of the criminal code that deals with property offenses, which many people find inappropriate because it reinforces this idea that animals are legal property rather than individuals that we should care for other reasons. There's some other problems with the criminal code as well. The term an animal or a bird is used in the code. So it says you can't cause unnecessary pain or suffering or injury to an animal or a bird. Well, you don't have to be somebody who writes the Oxford Dictionary to understand that an animal includes a bird. And if an animal or a bird are the categories, where does that leave reptiles? Where does that leave, other animals who don't fall into those categories? It's confusing, and it could use some changes. The words unnecessary pain, suffering, or injury as well have often been criticized by folks. So if some pain, suffering, or injury caused to an animal is unnecessary, then the corollary of that is that some is necessary. So what suffering is unnecessary and what suffering is necessary such that it's allowed by law? Well, in practice, this has tended to mean that if someone is inducing suffering for a profit-driven purpose, so if you're, say, a laboratory researcher and you want to cause animals to suffer incidental to some experimental purpose, that's fine. Same if you want to, say, do a branding of a cow, because that's part of your business, that would be considered acceptable as well. The idea of willful neglect is also problematic. If you think about those two words, willful and neglect, they're actually kind of the opposite of each other. Neglectfulness is a state of not taking action and not really planning the consequences of your action, whereas willful is very much the opposite. So there's been a lot of legitimate criticisms of the criminal code that have led people to want reform of the statute for a long time and have led people to feel like it's not sufficient. I will say my own view is that the criminal code, although it has these problems that we've identified, I think the laws are sufficient to prosecute under the criminal code in the way that it was intended to be used, which is mostly to deal with the dog kickers, the person who neglects and serves, a group of cats, examples of egregious cruelty that everyone in society agrees are wrong. The criminal code is generally pretty good at prosecuting these despite the deficiencies. But there are legitimate criticisms, and there have been some attempts to get some reforms made to the code. These attempts were not brought forward by animal rights activists. They were actually initially started by the Department of Justice, which examined the criminal code animal cruelty protections and concluded that there were problems and there needed to be changes. This is a table that explains all of the various attempts that were made starting in 1999 by the then Liberal government of Jean Chrétien to fix the loopholes in the criminal code and just make it easier to prosecute the cases of sadistic cruelty or abject neglect. And every time the bill would die in some way, finally a bill passed in 2008 that just increased penalties in the code. It didn't fix the substantive issues. And then after 2008, that kind of killed the momentum for the government to do much more. Now, just to use one of these bills as an example of how difficult it can be to get reform through, we're going to turn to Nathaniel Erskine-Smith. He is a Liberal MP. He's now the housing minister. Nathaniel's an MP in the city of Toronto. He was elected first in 2015 when Justin Trudeau's government came to power. And he happens to care about animal welfare, and he wanted to revive some version of this bill that kept dying. When he did that, he thought, well, this won't be contentious because these bills were previously Liberal government legislation. And as an MP in the Liberal government, he assumed, and we all assumed, that the Liberals would support that legislation. And I will say nothing in those attempts to reform the criminal code was contentious as far as legal experts were concerned. Nothing would have affected the operation of industries like laboratory research, like hunting and fishing, like farming. Really, it just tightened up loopholes and made it easier to prosecute the dog kickers. But when the bill started working its way through the legislative process, he encountered just ridiculous rhetoric that was very similar to rhetoric that was listened to in the early 2000s when the bill was first put forward. So I'm just going to share a couple examples of what was said. So the quote above is from a Canadian Alliance MP. The Canadian Alliance no longer exists. It was essentially the predecessor to the modern Conservative Party. But he talks about how his dog is his property and, there's practices on ranches that could be deemed cruelty to animals by some. And he, was generally opposed to the bill because he thought it would affect his lifestyle. It wouldn't have. We see almost identical rhetoric in 2016 from a Liberal MP, David de Burgh-Graham. He said that, the bill would put his family in prison for sustainably feeding themselves. So essentially implying that farming would all become illegal or could put people at risk of punishment, as well as people engaged in hunting, fishing, trapping, etc. And in fact, we did see these industries mobilize pretty extensively to block the bill. So these are just a few of the logos of hunting and fishing organizations that got together. They engaged in extensive legislative advocacy against the bill. And when it actually came time for a vote, we were all pretty troubled by the results because it lost by an astonishing margin, 198 to 84. The Prime Minister Trudeau, and his entire cabinet voted against the bill. And it was really just a few Liberals with a conscience, the NDP and the Greens, who voted for it. So I use that as an example of how difficult it can be to make changes in favor of animals that are not even contentious. And the reason that difficulty exists, of course, is partially due to the powerful industries that would prefer for the status quo to prevail and that see any attempt at legislative reform as something that could one day down the road lead to regulation of their industries. So just to give you a little peek at how powerful and how fearsome these industries are when it comes to lobbying, let me just take you back to a story from the National Post in 2018. So the Conservative Party was having a convention in Halifax. And one of the proposals on the table at the convention was a discussion of supply management. And supply management, you may or may not be very familiar with it, but it's essentially a system we have in Canada for some agricultural commodities, so dairy, eggs, chicken, turkey, for instance, where there's a cap set on production and a guaranteed price given to farmers. So farmers like this because it keeps prices artificially high for consumers and prices and profits high for them as well. A lot of free market economists don't like it because they think that the invisible hand in the free market should prevail. So we saw the dairy industry show up at this convention with a binder with a very sophisticated lobbying strategy that would have the right people in the right rooms at the right time speaking to the resolutions, and a very, very sophisticated strategy to try to kill supply management discussion. Fortunately for us, one of those people forgot their lobby binder on the floor of the convention, and some journalists found it. So we actually got to peel back the curtain a little bit and get a closer look at the extremely sophisticated strategies that these industries have. I also enjoy the segment from this article here where former Finance Minister Joe Oliver, who was a Harper-era finance minister, he's compared the dairy industry in particular to the famously uncompromising US gun lobby in the United States. Now, everyone knows the NRA has been very successful for years in shutting down any sort of gun control legislation, and the dairy industry has been successful in shooting down issues that affect them as well. At this convention, not only did they lobby inside the right resolution rooms at the right time, they also held a reception. This is just a few photos from Twitter that they posted at this reception. You see one of the Conservative leadership candidates, Andrew Scheer, who subsequently became leader, was there, glad handing at the reception. They had hospitality suites that folks could show up to and make connections there. Senators, MPs, party officials were all at these events. So they're powerful industries to attempt to compete with if you're an animal welfare advocate looking for stronger laws, and they have a very strong, influential voice with government. I'll show you an example of one ways that these industries use the influence that they have, in particular in the farming industry. Let's talk about animal transport for a minute. So in addition to the criminal code, animal transport regulation is one of the few things that we do have in Canada. Our transport laws were first enacted in 1976, and for a long time, they went unchanged over 40 years, leading people to be very, very concerned that the laws allowed for days at a time of transporting animals without food, water, or rest. So there were pushes by the animal welfare community to change that. And one of the issues that was most salient was the welfare effects experienced by spent hens. So hens who have reached the end of their egg production life cycle and are being sent to slaughter so they can be ground up for chicken nuggets. This is a table from access to information documents that an organization got from the government. You can see here in the red circle that the last column is the science column, essentially. So it says, how many hours can you transport an animal before you start to see detrimental effects? When it comes to spent hens, that number is 8. So next column in the middle, the proposed limit on transport for spent hens that the government put forward was 24 hours. Now, this was actually also against science. Here's another quote from those documents. So the government initially put forward 12 hours. It suggested that 12 hours should be the maximum amount of time that you can transport a spent hen. That wasn't supported by science either. It should have been 8, but 12 is a lot better than 24. But they say as a result of industry feedback, the CFIA, the Canadian Food Inspection Agency, adjusted its original proposal from those 12 hours up to 24 hours without food, water, or rest. And the CFIA is now content to propose 24 hours as a result of industry concerns. So if you think about it, that is a tripling of the time after which science says animals probably shouldn't be transported. And this type of thing is standard. Okay, so we've gone through a couple of problems with the rules that do exist. But largely the problem is that there simply aren't rules, right? So we don't have a National Animal Welfare Act. Most of these industries are just unlicensed, they're unregulated, and they're uninspected. Now, and I want to emphasize in particular that when it comes to farmed animals, their entire lives up until the day that they're transported to slaughter are not overseen by the government. So there's a huge gap there when it comes to farmed animals, but we're going to deal with a bunch of different areas of animal use and talk about all those. So what does fill the legal void? We've gone through why the laws that exist are insufficient, but when we don't even have actual laws to regulate an industry, something springs up to take its place. This actually leaves industries to create their own standards and police themselves. And so we're seeing the creeping privatization of animal protection laws. When animals are left with is voluntary guidelines, largely created by industries themselves that use animals to generate profit. And I'm sure it will come as no surprise to you to hear that those regimes don't usually prioritize animal welfare. They do prioritize keeping the systems going that use animals for farming, research, and other businesses or institutions. And we're going to go through a bunch of ways that the industry has stepped in to fill this legal void. And I would say the theory on why they're doing this and why they're creating rules at all for themselves is self-regulation avoids government regulation. So if there was a public push, which of course there always has been, to regulate conditions for farmed animals, for lab animals, for zoo animals, the industry can point to its own rules and say, oh, we've got something, guys. It's okay. Don't worry about us. So that, I think, is the cynical explanation for why they do this. Let's start by discussing animals used in experimentation and research, because I think the regime governing them is one of the most egregious and also one of the oldest enshrined in Canadian practice. So we currently do not have a single federal law protecting animals' use in research. And in fact, Canada is the only G7 country without legislation for animals used in experiments. Protections for animals used in research and experiments did become a public concern in the 1960s. And as a consequence of that, there was a report from the National Research Council. There was one from the Association of Universities and Colleges of Canada to develop some sort of system to oversee animals. At the time, the government decided that it didn't have the legal authority under the Constitution to regulate animals in labs. And so what was recommended was a Canadian Council on Animal Care, sort of a non-legal voluntary organization to provide some oversight. I don't think it's true that animals aren't a matter of federal authority under the Constitution. Perhaps that was more of a concern back then, but the way case law has evolved since, it is no longer true, certainly today. But it's led to where we are, so it's important to recognize. So we now do have a system called the Canadian Council on Animal Care. And I imagine some of you might be engaged or have worked in labs before and might be quite familiar with this system. But when it was recommended, it was created as a nonprofit organization. It receives federal funding, but it doesn't have any legal powers, and it can't perform any law enforcement functions. Yet the federal government defers almost entirely to the CCAC when it comes to issues involving animals used in research. So what it does do is it creates non-binding guidelines for animal care for animals used in experimentation and other forms of science. The creation of these guidelines is dominated by committees comprising those largely involved directly in animal experimentation themselves. The CCAC is an incredibly opaque organization. It's not subject to access to information regimes or transparency mechanisms. There's essentially no way for the public to know where the public funding that the organization receives is really going or being used. If you're in the business of animal experimentation, participation in the CCAC is actually not mandatory. For private labs, perhaps someone doing contract research testing on toxicity, there's no requirement to join. It's only a requirement to join and participate in CCA processes if you get federal funding from the CIHR or from NSERC. Yet, and despite of this notable degree of connection between the feds and certainly the federal funding power, neither the CCAC or any labs it oversees provide any modicum of transparency or allow public scrutiny. So it's very, very secretive. The CCAC delegates oversight of animals in labs mostly to local animal care committees at institutions like universities or companies who are doing testing. They get to decide what types of uses of animals and experimental proposals are acceptable. And those committees, again, are dominated by researchers themselves. CCAC itself could do an inspection of a facility up to every 3 years. They say that they would do 3 years, and then if there's no issues identified, they would do 5 years. These are announced inspections, so there would be every opportunity for a lab to clean itself up before the inspectors come along. And in all of its years of existence, I'm not aware of any evidence or publicly available information to suggest that the CCAC ever once recommended that the federal funding power be withdrawn over noncompliance with its policies. So questions over how effective it actually is remain. Another aspect to this, of course, is that the number of animals used in experiments in Canada has risen sharply over the past decade and is currently higher, much higher than in other comparable countries with even larger human populations. I'll say one exception to my comments about this being a largely voluntary regime, or that Ontario, as probably some of you are aware, does have regulation of laboratory use of animals under the Animals for Research Act. That has its own problems, but we don't have too much time to get into that today. If you want to know more about this, I really commend to you a report. You can access it through that QR code prepared by Animal Alliance of Canada that delves into all of these issues in great detail. All right, so that's the non-legal regime governing labs. Let's move now to the National Farm Animal Care Council, which is essentially the CCAC of the farming industry. So this is a nonprofit set up again by industry with the support of government and even some humane groups to create standards essentially that the farming industry should follow, but doesn't have to. It doesn't have any legal powers, once again, or authority. It creates these voluntary codes of practice that are supposed to be the national understanding of animal care requirements in Canada. It's dominated again by industry. Almost all of the industry of the players in this body are industry, sometimes government, but certainly most of them receive their incomes from the use of animals commercially. There's only 2 animal welfare organizations, World Animal Protection and Humane Canada, that are members. Members must approve and accept the use of animals in agriculture, so that actually bars quite a lot of folks who have fundamental problems with the system. And these codes of practice include, so quote unquote, requirements and recommendations, neither of which are really binding in any way. And the codes, I would say, highly prioritize profitability over animal welfare. And I'm going to take you through 1 or 2 of them actually as examples of how this codes process falls down. So you can see the the NFAC creates codes for quite a few animals. This is just a sampling of the ones that they've worked on recently. That's missing the last couple of years. They're constantly revising codes every 5 to 10 years. Codes are referenced, so they may have some legal impact, but they're certainly not laws. They're referenced in several provincial statutes, sometimes explicitly, sometimes vaguely. Typically, when they are referenced, they're incorporated not as a standard that must be followed, but as a defense if you're charged with cruelty. So if you cause distress to an animal, or if you're not following the codes, you don't get a slap on the wrist for not following the codes. It's only if a farmer were to cause distress with animals, to animals, and that distress is caused by practices that are outside the code's purview. So this is an incredibly important distinction because the codes operate more as a get out of jail free card if you are following them and cause distress, rather than any legal standard that must be adhered to. I spoke earlier about the exemptions, which I said we were going to come back to. That's now that we're coming back to it. The exemptions under provincial law, where you can cause distress to animals in farming if you're doing so in accordance with generally accepted and reasonable practices. There is no definition of what those practices actually are, but a lot of people would interpret the codes to mean those practices. So again, the codes provide a bit of a get out of jail free card, potentially, if they're interpreted as being that standard that exempts you from the purview of the law. Codes are also not enforced by government in any way. So industries want to quote unquote enforce the codes themselves rather than have government inspections. And we're now seeing industry groups trying to move into this space and develop their own sort of verification programs. These programs are always extremely opaque. The public has no way of knowing whether a farm complies with the codes, what the penalty is if they're not complying, how many inspections there might be, what the outcomes are of those inspections. There's really no publicly available information, or including audits of the enforcement system and whether it actually works. Okay, I'm gonna hope this video plays. Showing you a video of hens used for egg production on a battery cage farm. We're going to talk about the hen code and some failings with it. So ending the caging of hens has always been a very high priority for the animal welfare community because, and we're seeing countries like the US, the UK, even the entire EU and elsewhere in the globe are moving away from caging animals. Efforts in Canada exist as well, because tiny wire cages for hens here, quote unquote battery cages, where many hens are stuffed inside a very small wire cage, have been the norm. Often hens can't spread their wings in these cages. And we're seeing that, around 83% of hens in Canada are still stuck inside cages. So, sorry. There we go. Okay, so what does the NFAC hen code have to say about this? Well, there was a lot of advocacy being done when this code was being developed in 2016, asking the code committee to ban cages for hens because that's what society wanted and that's where society was going. What the committee did instead was issue a code that says that hens should be transitioned to enriched or non-cage housing systems by 2036. Okay, so that sounds kind of pretty good. Just to note, the top text of this is sort of describes what the purpose of codes is, which is not necessarily to promote animal welfare. The purpose of the codes is to provide acceptable standards of care for animals with achieving a workable balance between the welfare needs of animals and the capability of farmers. So keep that in mind because they're not purely about animal welfare. Okay, so the code said no more battery cages. You can use enriched cages or go cage free. And at the time, we were all very hopeful that this would mean an industry-wide transition to going cage-free because retailers and companies had committed to doing that, and it seemed like the supply just needed to catch up to those commitments. What we've seen instead is a move almost entirely towards enriched cages and almost no movement on getting hens out of cages. So battery cages on the left, some of the worst, tiniest confines, enriched cages on the right. Tell me if you can tell the difference. It is very, very hard to see the difference between these two types of cages. Enriched cages have a perch, they might have a scratching pad, they have a quote unquote nest in the back, which is really just a rubber flap where birds can lay eggs, and that's basically it. Not much better and not much more freedom for birds, but this is a direction that the industry is going in because the code allows for it. So we see the growth of cage-free in all these other countries, but not in Canada, and this is a direct consequence of the code prioritizing farmer profits and farmer preferences over animal welfare. Just talk about pigs for a minute. Gestation crates, again, one of the very top priorities for the animal welfare community out of concerns that mother pigs spend most of their lives in these tiny cages where they can't even turn around during use as breeders. In 2014, again, there was a huge public push for the codes to eliminate the use of gestation crates. And the 2014 Code of Practice looked decent. It said that sows do show an increase of behaviors that indicate stress when they're confined in these crates, and that there would be a new requirement that there should be, essentially very decent restrictions on the use of these cages. They should be housed in groups primarily. Okay, so that sounds pretty good. July 1st, 2024. So that was last year. What happened? Well, what actually happened is the pig industry just decided that it didn't want to follow the code. So it decided unilaterally on its own without an acceptable revision to the code that it simply wouldn't meet that process. And it could do this because the codes are not law, they're not a standard, they're simply voluntary guideline that can or cannot be followed by industry. And so this was really upsetting to a lot of people. Farmers basically decided that it was too complex. maybe more pricey than they expected, and they underestimated the complexity of the conversion, so they wouldn't meet the deadline, and they decided not to, and they didn't. So, likely about 60% of sows are raised in group housing systems right now. We don't really know for sure, but the rest are still confined in these miserable cages. Zoos are also not immune from self-regulation. So I did mention that there are some rules on the books at the provincial level protecting animals in zoos. We also have Canada's Accredited Zoos and Aquariums, which is a zoo industry charity that's essentially a lobby group and does accreditations for zoos and aquariums. The reason that this group sprang up, I would argue, is so that it could sort of occupy the space of regulation and stave off further regulation. So often what we see is that aquariums and zoos that meet the standards of CASA and are accredited are exempted from what would otherwise be bans on keeping many wild and exotic species in zoos. CASA standards are considered quite low by people in the wild animal welfare community. They're certainly lower than comparable regulators in other countries, but they've managed to prevent some regulations from being imposed on their members. So it exists as well in zoos, and even in fur trapping. There is an international agreement between several countries about essentially the quote-unquote humane trapping of fur. It's not humane, spoiler alert. That sought again to stave off regulation from coming and from bans on the import of animals who were killed in traps from happening in certain jurisdictions. So what there is now is there's an industry group called the Fur Institute of Canada that coordinates trapping research now and does actual trapping tests on animals to see how much they suffer in traps. And it decides essentially whether traps should be approved for use or not based on its own research, not based on government research and not based on public morals, but based again on research and interest from the fur industry. So the privatization of animal law exists in that sphere as well. All right, let's turn now to enforcement. We've got problems with animal law. What about animal law enforcement? The first thing that's obvious is that you can't enforce laws that don't exist. So we've seen over and over again that there simply aren't laws pertaining to many industries, or that if there are non-binding rules or guidelines, these are voluntary and they also can't be enforced. And of course, the industries even try to fight against public enforcement when there are laws that apply to them. So ranchers in BC, for instance, were very concerned about a pilot program the BC SPCA wanted to introduce, where it was going to randomly inspect a very small number of farms per year just to see how that went. And they pushed back very, very strongly against that. Enforcement also suffers from a real hodgepodge of agencies. So we might have SPCAs at the provincial level doing some enforcement. We might have police involved in it. Federal or provincial agencies like the Canadian Food Inspection Agency or AMAFRA. Sometimes all three of them are involved in potentially a complaint at the same time. This leads, I say, to buck passing. If one of these agencies can avoid responsibility for doing something by shunting it to the other agency, I see over and over again that that would be the case. The best example of this, I would say, is when there's a truck rollover of animals who are being transported to slaughter. This happens all the time, including regularly here in Ontario where I live. There might be a truck that rolls over and, say dozens of pigs are there and they're killed, or they're injured and they're wandering around. There's various laws that would make this type of situation unlawful and could lead to prosecution for the driver, the truck company, and various other parties. And there's federal transport laws, there's provincial animal welfare laws, and even the police under the criminal code have jurisdiction over driving offenses. So we file complaints against the trucking situation with all these agencies when these incidents occur, and they all say, oh, it's the job of the other one to do something about it. Another criticism of animal law enforcement is that it is often done at the provincial level by private charities. Most provinces still have this model. They are not government agencies that engage in law enforcement regularly, so they're often under-resourced. They may not get the funding they need. There may not be transparency and accountability because they're not government agencies. And I will say we had this concern in Ontario for a long time. Many people did over the actions of the OSPCA and the regime where the OSPCA as a charity enforced the laws. That led to a court case eventually, and it led to the OSPCA dropping out of enforcement. It led also to the government implementing animal welfare services to take over that function, which everybody applauded at the time because most people felt that government should be responsible for enforcing animal laws. I will say that was perhaps a mistake. Animal Welfare Services has been significantly worse than the OSPCA to deal with. It doesn't have a website. It has never issued a single news release. It refuses to share public information about its activities, including whether it lays charges. It won't give media interviews. It won't confirm enforcement action. It usually tries not to respond to FOI requests. It tried to charge us $40,000 recently for a response to an FOI request about some of its activities at Marineland after there'd been a conviction. It also has MOUs with industry associations, such that if it does show up to do an inspection or enforcement, it'll bring, say, the Pork Council to, or the Pork Producers Association to a pig farm if it's inspecting a pig farm. This wouldn't exist in any other industry, but it does for animals. Animal Welfare Services is also laying drastically fewer charges and orders than the OSPCA did, despite having a budget of $21 million, sorry, which is far more than the 5.75 that the OSPCA had. When governments do enforcement, they also often have a conflict of interest, and they prioritize business interests and the health of an industry rather than accountability. I'd say one of the best examples of this is the Canadian Food Inspection Agency. I'll give you a couple quick stories from some of the work that we're doing around the live export of horses to Japan for slaughter. This is an industry that Canadians find unacceptable. There's a federal bill in the House of Commons in the Senate right now to ban this practice, and there's been a lot of advocacy around that. We determined through investigations that we did on our own, including by working with people in Japan, that most of these flights are going above the 28-hour legal limit. And the CFIA was not bothering to police that whatsoever. Essentially, their position was that as soon as the flights left Canada, they wouldn't bother checking to see if the horses made it there within the 28 hours. We also found that despite CFIA telling a House of Commons committee recently that they were aware of only 5 horse deaths since 2013 from these shipments, we found from Government of Japan records that in just 1 year, 21 of these animals died during this terrifying and arduous journey. I would say the CFIA is more concerned with protecting that industry and enabling the pursuit of profit than it is with the welfare of the animals. All right, that's a lot of problems. I'm going to spend much less time on the solutions because I actually think they're fairly straightforward and not complicated, but it's mostly a problem of political will. When governments want to act, they do so decisively. One example is when governments wanted to stop undercover investigations from occurring of factory farms, of research laboratories, of slaughterhouses, through so-called ag gag laws, they passed these laws very quickly. Ontario did this, Alberta did this. They made it illegal to work undercover at a farmer slaughterhouse and other places in Alberta to gain evidence of animal cruelty. Several provinces now have ag gag laws. We've struck them down in Ontario, but I just use this as an example to say that when political will exists, things can happen quickly. So I hope we're going to start seeing will for solutions. The first solution to me is obvious. We need a federal Animal Welfare Act. There is jurisdiction for this. Regulating and overseeing industries with public welfare implications is what we do in Canada. It's what the modern regulatory state does. We need licensing for industries requiring animals, legal standards, and inspections from government to ensure those standards are being met. An act could also help provide a forum to progressively ban some of the worst practices. And I think that's important as well, is to over time phase out the things that no longer are socially acceptable. Standards under that act must be developed independently of industry. We see over and over again when industry is in charge, they will choose self-serving standards. It could be possible to create a law reform body like a commission. The Law Reform Commission has been a thing at the federal level to deal with tricky issues that governments don't necessarily want to touch. There can be better prospects of acceptance of new standards if law reform proposals are developed independently from government and industry lobby groups. And I think removing industry's special lobbying opportunities from the process is important to mute some of the power that we've seen from those industries. A commissioner of animal welfare is also a potential solution. That's a proposal that's been floated and is now happening in other jurisdictions, including at the EU level and places in Australia. And that's a federal position that would be in charge of auditing and overseeing and improving animal welfare in some respect. Again, I think going back to banning some of the practices that have become socially unacceptable, we have seen this starting to happen, and that's some of the bright spots that I see. The ban on whale and dolphin captivity that was passed in 2019, which has led to Marineland being a shadow of its former self, is really positive. There was a bill that included a phase out and a plan for the government to create to start phasing out animal toxicity tests in 23 that passed. The bill I mentioned to ban live horse export, I think caging farmed animals is an issue whose time has come, and we're going to start seeing legislative movement on that as well. And when it comes to enforcement by government, I think to reduce this conflict of interest that we see, we need to separate the oversight functions from industry promotion and protection. Transparency is a fundamental issue, ensuring that groups like Animal Justice or any of you could send a request and access information about what law enforcement is up to. Proactive inspection reports posted on the internet for all to see, rather than that information being closely guarded. And I'll just end with a novel approach that we've taken, which is private prosecution. Animal Justice recently laid a charge against a live horse exporter in Winnipeg over a transport of horses to Japan that went over the time limit, and was foreseeable that it would when they approved the shipment to leave. Canadian Food Inspection Agency had decided not to take action in this particular case. We thought that was egregious, and we decided that we would do so to help uphold the law. So another novel approach. I'm going to end on that note, and I know we've got a few minutes for questions, and also just mention, I'll leave this slide up, that, well, perhaps Georgia, you want to say more about this, but the next talk is going to be by Sophie Gaillard about recognizing sentience in law.